17 years after Francis Muruatitu and Thirimbu Mwangi were sentenced to death for the murder of businessman Lawrence Githinji, the case they had filed challenging their sentences was finally concluded in the highest court in the land. In a landmark decision, the Supreme Court ruling that the mandatory death sentence for persons convicted of murder was unconstitutional. The two convicts had argued that Section 204 of the Penal Code, which states that any person convicted of murder shall be sentenced to death, was contrary to the Constitution. Through their lawyers, they put forth the argument that every case was unique and should be judged on its own merit, arguments which the Supreme Court judges upheld. In the ruling, the judges found that Section 204 of the Penal Code essentially sent a message to murder convicts that even if they were hurt, it was only for the purposes of the record as the sentence was predetermined. They found that mitigation was an important element for a fair hearing.
There is no doubt in our minds that the sentencing is a crucial component of the trial. It is during sentencing that the court hears submissions that impact on sentencing. This necessarily means that the principle of fair trial must be accorded to the sentencing stage too.
But the petitioners did not stop there. They claimed that they had suffered in the segregated death row and asked for compensation for their suffering. The judges ruled that the appropriate remedy for the petitioners was to remit the matter to the High Court, the very same court which had the matter, to evaluate mitigating submissions and evaluate the appropriate sentence befitting the offense. The sentence rehearing, however, applies only to the two petitioners, with petitioners with similar cases directed to await appropriate guidelines from the Attorney General. The mitigating factors outlined by the judges applicable in the rehearing of the sentence for the conviction of murder charges include the age of the offender, whether one is a first offender, whether the offender pleaded guilty, the character of the offender, whether the offense was committed in response to gender-based violence, and any other factor the court considers relevant. The Supreme Court further directed the Attorney General, the National Assembly, the Senate, and Kenya Law Reform to come up with necessary amendments to address the illegalities in the law.
We now lay to rest the quagmire that has plagued the courts with regard to the mandatory nature of Section 204 of the Penal Code.
This yet another chapter in the fight to have the death sentence abolished. Wilkis Anyabwa, Citizen TV.